Good afternoon, everybody. I just want to welcome you all to our webinar today, and thank you for joining us. I see a bunch of people still logging in. So again, we're just going to get started as we go through. We have a lot of kind of topics to go through today, and I just want to welcome Donna Berger from Becker as our legal expert. And just remind everyone that we are not providing legal advice, but instead just kind of this is an educational, informative series that we do so that we just provide this information to you so that you have some actionable items from there. So welcome, Donna.
Oh, thank you, Brian. Good afternoon. Happy to be here.
Absolutely. So today we decided that we're going to kind of really dive into the HOA laws. There is a lot of changes in the past legislative session that went into effect in July. And I just do want to acknowledge that we had a lot of condo board members also join and submit a bunch of questions preliminarily. So thank you for those. We're going to dive into the HOA ones first, and then if there's time at the end, I know we'll have a few of those SIRS questions and a few of the other condo ones that keep rearing their ugly heads. So we'll try to get to those at the end as well. But before we get started, I just want to kind of talk through how this is going to go. We're going to have a couple poll questions and everything, and looking forward to really kind of doing a deep dive into some of the deadlines and what the laws mean to you as a board member, as a property manager, and everybody else that's been joining us. So speaking of which, we have a couple laws that went into effect in July. So Ness, if we can put up the first poll question. A lot of it talks about having a website. So really want to kind of get a understanding of, do you have a website for your community? Right.
Brian, while those answers are trickling in, do we want to talk about the bill with the shortest deadline that's coming up in 2 weeks?
Absolutely. That's why this first poll question came up. So this is great. So yeah, HB 59, that's the first law that went into effect in July. Don, you want to kind of talk about what the ramifications are of that law and what that deadline is?
Sure. So before October 1st, and we are now taping this on September 18th today. So before October 1st, every homeowners association has to provide their members either a physical or digital copy of the association's rules and covenants. Okay, now in many communities, they may have already done this, but I know from experience, Brian, that a lot of communities, they have not done this. And we're talking about a lot of documents here, a lot of pages. So the association, okay, wait, what do we have here? 81% have a website.
Good. That's great.
So the reason that's good for the purposes of this bill is the association can comply with this requirement, Brian, to provide all the members with the documents by posting it on their website, okay? So they can either post the documents or they can provide a direct link on the homepage of the website, but they have to send out notice if they're going to deliver these documents digitally. So they have to send an email notice to every owner who has agreed to receiving notices by email. And they also have to send notices via regular mail to all other owners who have not agreed to electronic consent. Now, conceivably, if you're a small HOA, you could also just regular mail the rules and covenants to everybody, or you could hand them out and get a receipt. But that's really only going to work probably in the smallest of homeowners associations. The other two things to be aware of is now every time that your homeowners association amends your covenants or your rules, you will have to go through this process again. Now, we always recommend, and I know you do too, Brian, that if you're going to change the rules, make sure they get in everybody's hands. But in some communities, they don't do that. And now every time you amend, you have to make sure that you give it out and distribute this to everybody. So remember that notice that I just mentioned about if you're going to provide these by a website, it has to go out by September 30th because these have to be distributed by October 1st.
Yeah, that's a big one. All of our managers are working on those now for the HOA compliance, and again, doing the posting on the website, letting everybody know, alerting them to that everything has been on the website, and most of it's there. I would say, fairly comfortable that most of our large associations are naturally putting things on the website
Sure.
anyways. It's just making sure that everybody is aware. I think that's critical. But that actually leads into our next poll question. So do you know if your managers actually have all the rules and covenants? And Ness, if you can put up the next poll question, I'll be curious to see how comfortable the board is with this question.
Well, I think this is interesting as well, because I think there's some confusion out there, Brian. The statute is worded to say rules and covenants. What does that mean? Everybody
Right.
knows, everybody has a pretty good grasp of what rules are, right? But covenants, typically that's the declaration of covenants. Does it also include the articles and the bylaws? This is where I would recommend you get a legal opinion. I have an opinion on this. Typically, the articles and the bylaws are exhibits to the declaration. And believe it or not, the intent of this legislation is to make sure your members know what the requirements are to live, if there's use restrictions. Sometimes those use restrictions are actually contained in the articles or the bylaws, believe it or not. So, I would say err on the side of caution, but speak to association counsel and figure out what covenants means and what you actually have to distribute to your members.
Yeah, we've been having that conversation with our PMs and our directors as well. And we kind of said, again, I like your err on the side of caution. We're basically providing everything. Anything that's been kind of done, let's make sure it's on the website. Let's really make sure that we do it. We're going to try to limit how much actually has to be physically mailed, just from an expense standpoint. What are your thoughts on the notice? If can they get a letter, a physical mail that just says, we are posting everything on the website? Does that count as basically receipt of notice?
Yeah, it actually says that you can comply that way. You can comply by posting it digitally, but you have to make sure that you follow the requirements for the notice, which
Gotcha.
is the mailing for those who have not agreed to receiving consent, to receiving notices electronically.
Do we have one of the questions that actually just came in? Great question. Do we have to track each resident's acceptance that they've received this notice, or we can just prove that the notice has been delivered?
Again, this is such a new law, so there hasn't been any litigation stemming from it yet. There haven't been any division oversight regarding it. I don't even think the division has released accompanying rules yet. But I would say, as when I work with associations, you try to follow exactly what the statute says. And the statute doesn't say that you need to obtain a written receipt or anything like that.
Yeah. That's we're kind of on the same page there. Is our pushing that email out or a physical mail is basically acting as receipt. They have received it, and honestly, if they don't, they're going to call us anyways, and we're going to just say, it's on the website, or here's a digital copy of it. So kind of working through there. So
Can we just say from the outset that the legislation is not entirely clear, and as much as some legislators say that they don't like attorneys all that much, they basically keep us employed year after year with all this legislation, because it is so confusing the way a lot of it is drafted.
Absolutely. There's always little nuances that kind of swing it one direction or the other, and get a couple different opinions. So, and it looks like from the poll results, only about 50% are comfortable that the rules and covenants are on the website. So I think this is going to be a big push over these next couple of weeks of your managers. And so that's going to be a big push that, hopefully, and if you haven't heard from your manager, maybe reach out, see how they're going to be responding to all this. So great. So that's HB 59. And so I wanted to, again, reiterate, we have a deadline, September 30th. It does say October 1st. So, sometimes there's always that little nuance. Does it the end of October?
Well, the notice you
notice.
have to remember, it said you have to comply before October 1st, 2024. The homeowner association must provide a copy. So,
Right.
I mean, that would be my recommendation. The language actually says before October 1st. And I think
Before
there's
October
30 days
1st.
in September.
Right.
So,
Perfect. So then the next one that was kind of such a sweeping change that really impacted everything was officially called HB 1203. And there were, and even from the preliminary questions that came in, a lot of comments, questions about this, this new change, this new law that went into effect. Can we maybe break down, and we'll kind of go in order of some of the changes that came in? And I guess probably more specifically, we asked the question about websites. One of the bigger changes was website compliance. So can we start there, and we'll just kind of go through each of
Sure.
these?
Website requirements. So up until now, HOAs, they weren't required to have a website. Condominiums were required if they had 150 or more units they were operating. That actually dropped down, Brian, to 25 for condos. For
Mhm.
HOAs, it's 100. So if a homeowners association operates or administers 100 or more parcels, they must now have an association website by January 1st, 2025. And there's certain documents they have to post on that website. So they have to post all the governing documents, all executory contracts. An executory contract is a contract that's not been fully performed. That's your landscape it's an ongoing contract. They have to post the budget, the financial report, monthly income and expense statements, current insurance policies, the board member certification for each director. And I know we're going to talk about the new board member educational requirements, Brian, later in the webinar. Any contracts or transactions for which a director has a real or potential conflict of interest will need to be posted on the website. Meeting notices. So there's a lot of things that need to be posted on the website. And just remember that the deadline to get that website up and running is January 1st, 2025. I also think it's really important, and I'd love your take on this, is that, listen, a lot of management companies provide websites. They provide the web pages. But when you transition, Brian, when you're taking over an association that has used another management company, sometimes there's a little bit of a couple time period where there's some problems getting information from the prior management company. If they shut down that website, that's a problem. That's a real problem. So I'd love to know what your take is on how to make that transition where an association is not left without having a website in place now that it's a mandatory requirement.
Yeah, it's a great question. When we've transitioned new accounts and worked on those, we start our transition about 30 days prior to our actual start date. And one of those kind of handoff roadmap discussions is, what website do they have? Are they already set up? Do they have everything that you just labeled already on there? If not, we actually move up the website production higher on our critical path list. It's important that we get that going. Again, we don't want the community to be upset that the website's not there. It's not fully updated. So we want to make sure that that gets going. And typically we're able to get most of those things done. If not, for whatever reason, a domain transfer, more on the technical side, what we try to do is e-blast the community and let them know it is in process. And so again, it's all about keeping the lines of communication open. The reason why somebody would complain is they're not getting the information that they're looking for, and that can happen during a transition. So we try to say, if you're looking for something specific, a financial document or anything else, call management. We can get that out to you as we are working through maybe the technical change from one domain to another, and that can happen. GoDaddy to some other platform as we build, and then we're building our platform that we work off of, and making sure that all the documents are listed and getting those together as we bring some stuff over. The other challenge sometimes when we're either coming from a self-manage or maybe a smaller, I'll call them mom and pop management companies, they may not have all the documentation immediately. So making sure that we're working through those challenges as we're getting geared up to start. Again, we typically start about 30 days. That's a normal out, but we've also started with 1 day's notice, and as you guys have as well.
I mean, it's something for our listeners to think about, for our boards to think about, because again, if this is a requirement that you have a website up, and also we know now that you can provide, you can basically direct the document inspection process, and we're going to talk about that in a few minutes. Yep. Digitally, and direct people to the website. It's going to be critical that you keep that website up and running. So that's something that you should talk to your management company about, talk to your counsel about covering that in your management agreement.
No, absolutely. And that's where, we've built, different checklists and different processes. And I know we're going to talk about it. We kind of, the document kind of inspection piece, because now we have to have that checklist and get things ready to go and understand that people are signing off on that now. And so, yeah, it's important for us, and we, put it on our critical path item just as much as getting all the roster information over. It's making sure that those platforms are set up timely, because it's all about communication out to the residents. So the next thing that came up in this law was now the continuing education for board members. And if you're a new board member or existing board member, who can even provide those courses? What do they need? So maybe we can talk a little bit about what that new law implemented for these board members.
Yeah, it implemented a lot of education, Brian. And look, we have almost 300 people on this webinar right now, and nobody's requiring them to be here. So there's definitely a thirst for education out there.
Right.
I mean, I see it all the time. I'm so heartened when I see all my board members attending a bunch of classes, not because they're required to, but because they want to. That being said, HB 1203 did impose mandatory educational requirements. This is also true. 1021, which was the condo bill, also imposed mandatory education. Remember, in the past, directors had the option to either attend a course or to sign a form saying, I've read, understand, and will uphold the governing documents. Now you have to be educated. So an HOA director must complete 4 hours of education at least every 4 years, unless they operate more than 2,500 parcels, in which case it's 8 hours of continuing education every 4 years. Now, what's coming up, the questions that are coming up is this law went into effect, Brian, on July 1st. Let's say I'm already a director. Do I have to take the 4 hours of continuing education? The division has said to us that directors who were serving before July 1st, they have 4 years to take that first course. Okay, and then every 4 years you take it. Who can provide the courses? Well, DBPR has released courses. There's law firms like mine that have our courses up and running. You have to be approved by the state. Your content, your curriculum has to be approved because there's specific curriculum that has to be covered. For instance, your curriculum must include training related to financial literacy and transparency, record keeping, levying fines, and notice and meeting requirements.
Right.
And lastly, I would say with regard to education, Brian, that if you fail to do this, if you're an HOA director and you just don't do it, you are automatically suspended from the board, and the board may temporarily fill your seat. And then as soon as you get your course certification in, you're back on the board.
Oh, okay. So they could actually, remove an individual, a director, even president or whomever, remove them for the time period until they get their course taken care of.
And you don't even need to vote to remove them. They are removed by application of law. The only action the board has to take at that point, if you have a director, whether it's the president or any other officer or director who has not complied with these educational requirements, the only action the board has to take is to vote to temporarily fill that seat. In other words, they don't have to take a vote to say, we're voting Brian off because you didn't take the course.
Right.
Brian, the law
Just naturally
removes you. Right.
Yeah. Wow. So I think that's going to be interesting because the board has to understand who has and who hasn't, and they need to have that information readily available and take care of it. And it's important, like you mentioned. There's a lot. We have almost 300 people on here. The desire to have knowledge about their HOA is so important and critical, and we try to do a number of different coffees with Castle or town halls, and for not just the board but the membership as well. There's a we always say when there's a lack of information, lack of communication about some of these things, people fill it with rumor and speculation, and it causes a lot more issues than if they just took the course, understand what's happening in the association, what their requirements are. So that's important.
I would just add, listen, I know I speak to so many directors, some of them think this is punitive. I have a different perspective. I think this is helpful, as you just said, because there are potential personal liabilities now associated with serving on your board of directors, whether it's a cooperative board, a condo board, or an HOA board. So you need this education to know where the landmines are and how to protect yourself when you're serving as a director.
Right. So a couple questions are coming in just for clarity on if they are sitting director already, So, and again, this law went into effect July 1st. So let's just say they were voted on June 1st. They're now sitting board of director. They have 4 years to take their 4-hour course.
This is for HOA directors. Remember, we're
Yes,
talking about
HOA.
1203. We're not talking about condominium directors. But according to what the DBPR has advised, it's for directors who are newly elected or appointed after July 1st, have 90 days to get their 4 hours of education in. If you were sitting on your board prior to July 1st, which was the effective date, you've got 4 years to take the board certification, okay? Because it's every 4 years. I would urge you to take it sooner, because
Yeah.
there's so many things you need to know. What we have been talking about, and we're going to continue talking about for the remainder of this hour, that I wouldn't wait 4 years if you're a sitting director to take your course. And again, this is subject to change, folks, because the DBPR may come out and they may release a rule saying no. They've been known to reverse themselves.
All right. But again, it's what harm can be had by taking a new little bit of a course here, a course there, going through some other continuing education, taking it every single year just so that you're very comfortable. Again, we always talk to our boards when we do kind of board orientation. A lot of new members come on, and we talk to them. You're running an organization. You're running a multi-million-dollar company. And we require all of our teammates to go through different trainings and things like that. So it's the same kind of philosophy as we go through this. It's really important.
Yeah.
Actually, I want to go back one to the website compliance. There's a few questions that came up, and one, how long do they have to post some of these items, like their monthly financials? Does that have to be 30 days after the month end? Every 6 months they get uploaded? Is there any requirements within the statute now says exactly how long in order to post an item?
So the statute doesn't say that. We anticipate that there will be division rules that may address this, but the litmus test is usually reasonability. So a reasonable time. You're not going to want things to back up. So that's another important point, that you've got this website. Somebody needs to be monitoring it. Somebody needs to make sure that the content is being uploaded, that when you do have contracts, you're uploading them. You've signed an addendum to that contract. That addendum gets uploaded. The meeting minutes get uploaded. Somebody's uploading the notices to that website. So it's not a static thing. You can't just put a website up and forget about it.
Right. Yeah.
You
And
need somebody overseeing it.
Yeah, and we have our managers or our admin, somebody within the organization, especially after each board meeting, the minutes get approved. The next day, that's their main kind of top 5 task, is start uploading everything. They've approved the financials, things like that. When you get your audited financials, getting those out to the community and up and noticed. Especially the one question that they also had is about the executory contracts. Putting all the contracts up on the website. Again, it's transparency is really what it boils down to, is here's our contracts that we have. I know for the condo side, it's a list of the contracts, not necessarily all the physical ones. So there's some little nuances there as we go through.
Well, you're also going to want a password protected page on this site. You're going to want a public facing website, and then the private page for your members, where you're going to put the more sensitive information, your financials, your monthly income and expense, your contracts, things like that, even your meeting minutes. I don't know that you want that open to the public.
Right. No, definitely. We've always, the important stuff, you maybe want your documents, your main kind of like articles of incorporation and everything else, put those out to the public. Those are great. But yeah, everything else should be behind, we call it a platform. So you have your website, and then you kind of have your portal, your platform from a resident standpoint to be able to go and search up any information that they may have. So which is good. Again, for us, it's transparency. It's, fill that information with the real facts, not allowing, the Facebooks and next doors to kind of be the fact. It's, come to the management company. Here's our website. Here's where the information is held. So speaking of holding that information about the records retention, I think it kind of leads right into some of the new requirements for records retention.
So I hope everyone listening has a document inspection rule in place, although I will tell you, Brian, from experience, that a lot of homeowners associations and even condos don't have that rule. For our directors listening, that needs to be on your to-do list. So the association under this new law must adopt a written rule regarding how the association records are to be retained. The statute says that it's a 7-year retention period for most documents, unless the association's governing documents require a longer period of time for retention. And here's where we have to talk about penalties, Brian. So the drafters of and sponsors of HB 1203, they had a mission in mind. And you mentioned it before, it was transparency. They want to make sure that homeowners association members are given access to their documents, that they have regular meetings, that they know what's going on. Now, you and I know that sometimes people are kind of apathetic, but for the ones that aren't apathetic and they want to know what's going on, they should be able to attend meetings and speak and look at the documents. So there are severe penalties associated with the document inspection process. If there is a knowing, willful, and repeated failure to produce the documents, that's a misdemeanor of the 2nd degree. Now, it's important to know that repeated may mean something different to our listeners than it means to the legislature. Under the legislature's identification, it's 2 times in a 12-month period. Now, I do want to tell you, I have an example I always use, which is a community of ours that was impacted greatly by Ian out in Southwest Florida. And the person who liked to make document inspection requests was just hammering them at a time when the association was struggling to recover from the effects of Ian. So they missed 2 document inspection requests because they were drying in and drying out units and dealing with the clubhouse and everything else. So it's really important that your board and your management professionals understand who's doing what. And of course, if for whatever reason you have a director who is not producing the records, or even a manager who's not producing the records to cover up a crime, that's a crime. So that in and of itself is a felony.
Yeah, it's important, and I agree with you. I think every association should adopt some form, or they must adopt a records request process. Again, because you also don't want to inundate management with all of this information, and most of the questions are easy. Hey, can I get a copy of the financials? Go to the website. That's the easy one. But when there's some deeper dive questions, it is a process that takes the manager away from truly managing the community. Are there any requirements on how many records requests an individual can make in a certain time frame?
Well, this is where you would work with association counsel. So I've drafted many document inspection rules. And you kind of, again, we get back to what's reasonable. If somebody is making, document inspection requests for the same documents over and over again, we may prohibit that. If we've just produced all these documents and now, 15 days later, you're submitting a new request for the same documents, that may be seen as harassment, a nuisance, what have you. So this is where you want to work with your association counsel to kind of create a framework for this document inspection process.
Yeah, no, it is true. And I think, as this law was coming out, it was to get that transparency together. Here's everything that our associate, we're not hiding anything. And I think most boards act this way anyways. And again, there's always one bad apple spoils a bunch. There's a phrase for a reason. I think this law kind of is trying to focus on that one bad apple that is kind of implementing all these new rules, but it's for the right reason. I think the intent is good, which is, guys, there's all this information. If you have a question, here it is. And then from a management standpoint, tracking when those requests come in, making sure that we get that information out quickly, timely, because again, it's making sure that the information is true and factual, and rumors and all this other stuff don't start and permeate through the association.
I would urge people to get out of the document inspection process altogether. Get everything scanned, updated, uploaded to your website or a mobile app. The new law also says you can use a mobile app to distribute these documents. I know a lot of homeowners associations and condo associations have committees. I've yet to hear anybody say we have a scanning committee, Brian, but I think we need to get a scanning committee. All those people who want to volunteer in your HOA, put them to work scanning all your documents so you can get it uploaded to a website or a mobile app and get out of the inspection process altogether. That way, whoever wants to see everything, it's all uploaded.
Exactly right. And that's what we really try to push our team to do is get the information uploaded. The last thing we want is filing cabinets just full of documents. from a time it takes a manager to go find a random invoice or whatever. And most of our data is either in our accounting platform, easy to pull up invoices, or as you mentioned, the mobile application. Everybody has their cell phone walking around, and we have the platform that people can just log into and go read the documents. Again, trying to free up the time for the manager to go manage projects, go manage other major things that are happening throughout the community is really, I think, the most important aspect of this is get the manager back to managing.
100%.
So the next big item that came up was kind of the new architectural controls. And, from internal, I think there were some kind of internal things within the architectural control, which I don't think a lot of associations have really dealt with in the past, is what can be done inside of your home. Can you touch on like what that law did? And then, well, I think the next piece of that is, the hurricane component of those architectural controls, which is another big piece. So we'll talk about the internal changes into your home and stuff like that.
So the architectural control piece of this new law is so important, Brian, because when you think about the function of a homeowners association, why do people buy in an HOA in the first place, right? And normally they're going to give you a few answers. One is security. Two could be amenities. I want to live on a golf course. I want to live in a certain area. I want a clubhouse. I want a gym, all these things. But a lot of times, one of the top three answers is because I don't want to be living next to a purple home. I don't want to be living next to a house that's, in a decrepit condition. I don't want to have a car next door up on cinder blocks. That's not so aesthetics are important to people who live in homeowners associations. For the HOA, particularly in the single family home communities, Brian, this is what people are looking for. They're looking for a beautiful experience when they go into the community. So this was interesting because effective May 28th, remember this became effective even earlier, if an architectural request is denied, the association must provide written notice of the denial, which includes the specific rule or covenant on which the denial is based. So you can't just have your manager or your board member tell somebody who says, hey, I want to change the landscaping in my front yard. You can't just say no. Or I want to put a shed up. You can't just say no. You have to say no, and here's why we're saying no. This law makes a few other changes, Brian, and that says that if I want to put a shed, let's say, in my backyard, and no one can see it, it's not visible from the frontage of the lot, there's not an adjacent neighbor who can see it, and there's not an adjacent common area like a golf course, where somebody could see it. You can't deny those requests now. You mentioned interior modifications, and I don't quite know why they went here with this legislation, but it said the HOA may not place limits on interior modifications that are not visible from the lot's frontage, from an adjacent parcel owner, or from an adjacent common area. So I don't know if associations were somehow saying you can't do this or that inside your home. Maybe it's because in some homeowners associations, there are attached, we have attached townhomes, and maybe it was the feeling that, you could structurally impact by the interior modifications. But now I think this is a conversation with council. If you do have concerns that somebody's doing something in that kind of homeowners association, where an interior modification might impact the structure, the shared structure, that's a conversation with council. Because they made this change to 720, and I do believe they may have thought everything's just single family homes. And we know that's not the case.
Correct. And I think maybe even an extension of that is, if you're adding, sorry to use extension twice, but adding an extension to your home, maybe you're building a in-law suite of some kind, which would have some interior modifications. You're opening up a wall, you're adding, extending the roof line. So I'm wondering if certain things were happening, which necessitated this law to try to kind of corral, adding onto these homes and things like that. But it's an interesting one.
Well, let me add to this also. You could air conditioning units, generators, heating components, all of these things that you see on the outside of a home. Also, this law says you can't just deny that. If it's not visible, but B, if there's other items like this already in the community. So I live in a homeowners association. I have one of those big whole house generators.
Oh yeah.
Neighbors have them. I hope it works. Haven't had to have it so far this season.
Let's knock on wood. We're halfway through the season. Yep, halfway through.
Exactly. October's normally pretty pretty busy, pretty active month. But so think about that too. So you've also got these architectural control changes as it relates to the items like heating, air conditioning, generators, things like that.
Right. No, I think that's important. A couple of the questions that are coming in is, okay, so, and you mentioned if they got a denial, is there an appeal process? Can a homeowner who got the denial for XYZ reasons, now because maybe it doesn't match the documents and things like that, is there still an appeal process that they can now appeal back to the board?
The appeal process is called the circuit court. That's always an option.
Right.
But listen, there could be an appeal process baked right into a particular HOA's governing documents. So they may have a more specific protocol for this, but in the statute, no.
Right. Okay. No, that's good. And then, a couple, it's funny. There's a lot of specific questions as it pertains to architectural controls, above ground pools, metal roofs. There's a lot of different things that I'm seeing coming through the questions here. And it's really going to tie back to what your architectural policies are based on your documents and things of that nature. And a lot of them, like the metal roof one, for example, is there's some new technology that are out there. So it's a new product versus, maybe some of our classic clay barrel tile roofs that
we
are.
need to talk about the metal roof. So I can launch into that, but I want to talk about the above ground pool. It's very interesting because in some communities they may say no, but now think about the new language here. Is that above ground pool? Is it visible from the frontage of the home? Probably not, unless you had a courtyard style house. Is it visible from a neighbor's parcel? Maybe, maybe not. Is it visible from an adjacent common area? So again, I would leave our listeners with this. If you really need to have a review of your current architectural control provisions and with council and see which ones you can continue to enforce and which ones you may not be able to enforce any longer and you need to revise. And if you've got provisions in there that are no longer enforceable, my recommendation is going to be revise it because you don't want that laying around to confuse somebody. But you mentioned metal roofs. Do you want to talk about that?
I do, but even from the above ground pool piece, just the liability, if there's a crack or that breaks and all of that water now, depending, especially with our zero lot line homes in certain communities, you're putting tens of thousands of gallons of water into a very small confined space. There could be some liability issues and damage to neighboring property. So I agree with you. It's let's review the architectural standards that you've set up for the association with council to make sure what can we control and maybe if there are some liability issues.
And there may be a glitch bill next year because as we see, a lot of times Tallahassee drafts these bills and they do not take all of the unintended consequences into effect. So they're not taking that into account.
Right. No, it's good. So yeah, let's jump into the metal roof conversation, which is always going to be a fun one. I've sat in a couple architectural meetings, so the metal roof one is always a fun topic.
So this actually comes into play under House Bill 293, which was hurricane specifications. This bill said it was intended to apply retroactively. And when we talk about the parking and vehicles, there's that whole question, does it apply retroactively or not? This bill does apply retroactively to every homeowners association as public policy in Florida, Brian. And it says every HOA must adopt hurricane protection specifications. So what does that mean? It means that they can adopt specifications regarding color, style, and other factors deemed relevant by the board with regard to impact windows, with regard to hurricane shutters, and metal roofs are considered to be hurricane protection. But there's also language in the bill that says the board or committee may require an owner to adhere to an existing unified building scheme regarding the external appearance of the structure or other improvement on the parcel. The specifications must comply with the applicable building code. The association may not deny requests which comply with the association specifications. Where this is going to get a little confusing is that a metal roof is considered hurricane protection. So let's say I live in an Addison Meisner, beautiful community, it's Mediterranean. Can I put my metal roof in? Every other roof looks like we're in Portugal or Spain. I've got my metal roof because darn it, it's great hurricane protection. This is where you need a legal opinion, but remember the language says The board or committee may require an owner to adhere to an existing unified building scheme regarding the external appearance of the structure. So to me, that's like the get out of free jail card, which says, if there's no other metal roof in here and our external scheme is, again, like an Addison Meisner Mediterranean look, you're gonna wanna talk to council when reviewing that architectural request for that metal roof. Now, if you've got other metal roofs in there and you just don't like the person who's making this request, you're not gonna be able to deny that.
Or the color. I've seen a few different color, or even a few different styles of metal roof. You know, a lot of the new ones are coming out with a almost like a clay barrel tile roof coating over the top, you know, a granular finish. So they actually have that same look and appeal. They're trying to appease some of these architectural controls that have not allowed the metal roofs to come in, because it's going to change the look and feel of the associations. I think the same thing happened when they went from barrel tile to like the slate smooth tiles, and now adding this piece. But you brought up, you know, a lot of the hurricane piece, now that they are hurricane protection. Actually, Ness, can you put up the next poll question, which really dives more into the hurricane specs that happened, and it's all about having the rules for windows and shutters, you know, and hurricanes in place. Do you have those specifications for your community?
You know, Brian, this is where precedent becomes so important. So remember, the law and the new law is basically saying, hey, board, if you've allowed something like this before, if you've allowed that giant generator or that giant AC unit in that location in one home in the community, you're going to have to allow it for everyone. Now, before, people could go to court and say, hey, there's selective enforcement. That would be their affirmative defense. But now we actually have the law saying, if you've made this precedent, if you've set this precedent before, it's going to apply. This is where rogue board members can create real problems for a homeowners association. Yeah. So I'm going to again recommend, and I've done this throughout a number of webinars, a board member code of conduct. I don't know if you're seeing more of those, Brian, in the communities you manage. I'm doing a lot of them, just so there's, again, a framework for people know, so the board members all understand who does what the expectations are, how the meetings and the communications should you know, be handled.
It really is good. We've seen a lot of of our association implement the code of conduct. A lot of times it's a result of maybe not the best communication styles that have happened in different board meetings. But I like taking the more proactive approach and started making a universal code of conduct. And it's not to restrict communication or anything like that. It's just to make sure that if, as you mentioned, if you've already set precedent, how you have to keep with precedent, or, you know, things like that. So it's putting those out, and it goes back to our first conversation about having the new CEUs and educational tools in front of them. You know, again, we're asking our volunteers of the community to sit in front of the rest of the community and make decisions that are best for the community. And so having them have all the tools necessary to make those decisions is very, very important. So it looks like, yeah, about 40 some odd percent yes, which is good. But that means we have about 60% that, you know, we need to maybe provide some guidance on what the windows and shutter rules in place. And again, it goes back to your architectural, you know, comments, you know, now that you have to have hurricane specifications in place.
Right. Now, in my opinion, not as big a deal for HOAs as it is for condos.
Very true. Right.
I mean, multifamily buildings, it's a whole different ballgame.
Mm-hmm. So then I want to get into kind of jumping topics off of hurricanes. Hopefully, again, we've knocked on a bunch of wood today, which was, you know, that we're through and get through season. Fingers crossed, we're good. But the financial requests, actually a few Q&As were coming through here. Again, going back to the website and having everything posted, but the financial requests for accounting records. And what does that look like? What are they entitled to? You know, is it just the ledger? Like a lot of times we get phone calls from residents. Hey, I need a ledger. I got a late letter. Can I have a copy of my ledger? And it's an instant transmission of that information. So curious why this component of the law came into effect.
I think this request for an accounting language was born out of the Hammocks HOA fraud case in Miami-Dade. That's my belief that basically the legislature felt that owners were not being told in sufficient detail what they owed to an association. So there's now language that says an owner may make a written request to the board for a detailed accounting of any amounts he or she owes to the HOA, and the board must provide such information within 15 business days after receipt of such written request. Now, you said, is that a ledger? Who knows? The
Right.
section says detailed accounting of any amounts he or she owes. I would assume the ledger's the most detailed accounting. You'll tell me this is
Mhm.
more your area of
Right.
expertise than mine. But if that's I would give them the ledger. I would assume that's the most detailed information you would have related to what they owe. Now that would include regular assessments, special assessments, any fines, maybe anything related to self-help. Maybe you've got language in your HOA and this individual ran through your guard gate. And you've got
Mhm.
language in your governing documents that says you can add the cost to replace that guard gate onto that owner's ledger. Here's the thing, if the HOA fails to provide this accounting by the deadline, remember 15 business days,
Yep.
the HOA waives the right to pursue the owner for any outstanding fines which are more than 30 days past due and for which the HOA has not given prior written notice of the imposition of those fines. I realize this is all very confusing language. Folks, you don't have to be writing this down. But what it does tell you is when you get that request for it's written, and remember, emails count as writing. So
Mhm.
somebody says, I want to know what I owe. Make sure you comply within the 15 business days.
Right. Now, and it's a great question, kind of segue. So we use the term ledger, which is basically every kind of transaction you have as a homeowner has made over the years, which then could have fines, any special assessments, things of that nature will also be included on that ledger. If you provide the letter and they have follow-up questions, does that start the 15 days over, or is that still in continuance? If I respond, well, here's your ledger, detailed accounting of everything that you've done, uh, I would say that ends that 15-day requirement. If they have follow-up questions, it starts a new 15-day clock.
I knew you were going to ask me a question like this, Brian. Again, we don't know yet, but here's the thing. Let's say you give them your ledger and they've got a question and they say this is not detailed enough. It is possible that in some instances, the ledgers, not everybody is fortunate enough to use Castle. You may have a self-managed place and the ledger may be missing a fine or two. So I would engage in an interactive conversation and get them what they need. I think, and I've seen this in my experience over the years, as long as you're being reasonable, as long as you're acting in good faith, you'll be able to show that to the division in the event that a complaint is filed, or you'll be able to show that to the arbitrator or the judge or the mediator. You want to be acting in good faith. You want to be trying to help these people get what they need. That doesn't mean you have to, be a doormat in the process. But again, if it gets to that point, if you can't shut it down with the accounting, here's your ledger. Next step, reach out to counsel and ask what your ongoing obligations are.
No, I totally agree. And I think that's, we try to, and we call it kind of our royal service, customer service side of things. Like, let's get the information out. Again, we're completely transparent. This is what we have. If there are questions, we do try to answer those. I got a fine for a violation. Well, I thought that was cleared up, or, and work with the on-site management team to maybe kind of drill in a little bit more. And I think a lot of times, I think where this law came from is people weren't getting the answers when they were asking them. And so the law had to be created to kind of force the hand of maybe again, I'll go back to the bad apple comment, a bad apple manager that wasn't providing that information timely. So I think it's important that, we get that information out and start the chain of communication. And if it really does get to that impasse, I don't believe it. The numbers don't match up, things like that. I totally agree, Donna. We got to bring in counsel to kind of act as the mediator in between the two to see what else we should provide or how the accounting should be handled. Which then gets into kind of not just the financial side of things, but the overall document and inspection process. We talked a little bit about it, about the retention of records, and then working through the document request and maybe some violations of non-compliance. What does that look like? We've implemented, again, a checklist. When Mr. Smith asks for a certain laundry list of items, typically it's not one, it's the laundry list. It's here's the checklist and confirmation that they've received them. we transmitted these items on this day, and they sign off either digitally or, if it's a PDF of some kind. What are some of the violations if those documents aren't conveyed properly and timely in the inspection process?
Well, a couple different things. There's statutory fines on a per day basis, up to 10 days. So you're gonna be paying money out of pocket. And the other thing is what we talked about, Brian. If you knowingly, willfully, and repeatedly fail to produce the
Right.
documents, that's a misdemeanor. And if you're doing it to cover up something bad, cover up a crime, that's a felony.
Yeah.
So you've got statutory penalties, you've got potential criminal penalties. Bottom line is you need to know who's doing what in the document inspection process. I think it's important to understand overall what the intent of this legislation was. This was born out of a lot of years of complaints to various legislators about bad behavior in homeowners associations. They're not holding meetings. I can't get my documents. There's just a cloak of secrecy over everything. They're trying to find me, but I can't find out why I owe this money. All of this. So if you kind of have a broader perspective of the problems the legislature was trying to solve, even if you don't have those problems in your community, you can understand why you're being asked to comply with certain things.
No, absolutely. And I just looked down at the clock, and wow, like I said, it's a meaty topic and there's a lot of stuff here. I want to kind of touch on two more quick things. And then one of the big items that's coming up with a deadline at the end of this year is the Corporate Transparency Act. So I just want to kind of round out 1203 first, which was like the overall fining implementation piece of 1203. If you can kind of touch on what that looks like now and what management and the team should be doing.
Sure. So fining is going to be important. And I know a lot of HOAs who do have fining and grievance committees in place. Fining and suspension hearings must be held within 90 days after issuance of a written notice of opportunity to the violator to appear. The statute now says the hearing may be held by phone or Zoom. So if you were requiring your violators to come in person, you can no longer do that. They have the option to attend the hearing by phone or Zoom. The fining committee must present its decision within 7 days from the hearing. Here's a big change. If the violation is cured before the committee hearing or cured by the deadline you gave to cure it, like move your car, clean up your yard, whatever, a fine or suspension cannot be imposed. So you can't be punitive like, okay, they fixed it, but we're still going to fine you.
Fine them. Right.
This is huge. Fines may not be imposed for leaving garbage cans at the curb or the end of your driveway with 24 hours before or after the designated pickup. So if your HOA was rushing to find people that didn't take in their garbage cans, you can't do that within 24 hours before or after, or if they put them out too early. And the same thing for leaving holiday decorations up or lights for longer than permitted. So you can't fine for that unless those holiday lights are left up for longer than 1 week after the association notifies the owner of the violation. So let's say your documents say lights have to be taken down within 12 days after the holiday passes. In the past, you start fining right then after the 12 days. Now this law says you have to notify them of the 12 days have passed, we're going to fine you. And so it's giving more time to owners to correct that. I do want to talk quickly about parking because it's a huge part of this bill. HOA cannot prohibit an owner, tenant, guest, or invitee of an owner from parking his or her personal vehicle, including a pickup truck, in the owner's driveway or in any other area in which those people, the owner, the owner's tenants, guests, or invitees, have the right to park, public streets. Also, work vehicles cannot be prohibited, nor can first responder vehicles.
Right.
So I know in my community, we got a big Sprinter van. That's going to have to stay that, you got a lot going on here. I would say that as association counsel, we are analyzing whether or not these restrictions regarding vehicles are retroactive. And we're going to talk about Kaufman language with our clients, or whether or not you can continue to enforce your vehicle restrictions. So that's a conversation with counsel. This is not a one size fits all equation here. And parking is a huge issue in a lot of communities.
It really is. We have it a lot, either the roads weren't wide enough and people are parking on the street where they should be allowed to, and then, emergency vehicles can't pass. Yeah, it's a big one. So we always recommend, let's review the documents, review the rules, and then bring in legal counsel, with some of these changes, what are we allowed to do? And I know we should have spent a little bit more time on it because it's a big item, but the Corporate Transparency Act, CTA, which is basically the deadline for completion, is the end of this year, December 31st, 24. So with the last couple of minutes, I know there's stuff happening. We as management are going to be rolling out a program to start getting board members to comply, but also know there's some lawsuits that are happening to maybe overturn this act.
Yeah, so really quick, this is an act that is designed to thwart money laundering and other nefarious activities in small businesses. Unfortunately, this is one where community associations got wrapped up in this. And folks, this applies to condos, cooperative, and homeowners associations. Basically, volunteer directors are seen under this law as being beneficial owners of the association. So the government, the federal government, wants you to submit certain personal information, date of birth, identifying documents like a birth certificate or a driver's license, to FinCEN by the end of this year. There are lawsuits pending. There is a lawsuit in Alabama. There was a lawsuit in Maine. And there's now been a lawsuit filed by CAI, the Community Associations Institute. What we've seen in the other two lawsuits is that the law was stayed with regard to those plaintiffs, but not with regard to everybody else. So you had to be a member of that plaintiff class to be able to have the CTA stayed with regard to your entity. Now that CAI has gotten into this game, and you can go to their website and get more information about their lawsuit, it could potentially apply to your association and stay the law in terms of application to your community. So you'll need more information. I would urge people to go to CAI's website and check that out. I was fortunate to have Don Ballman on my podcast. We're releasing that I think in 2 weeks. So great. I mean, I hope CAI gets this done, because it's ridiculous that board members would have to be submitting their information. It's not a fun job to start with, but now the government wants to make it even more difficult.
No, agreed. And I think from our standpoint, from management standpoint, we're going to be, alerting the boards that it is out there. And right now it's still law. So we still have to comply, still have to move forward. It may get overturned, or it may get overturned in 2025 or beyond.
The penalties are $500 a day.
Yes.
If you don't comply. If you give misinformation, you can go to jail. So to your point,
very
it's an
serious.
important point. Right now, you better be prepared to comply.
Absolutely. And so that's where we're going to be pushing out this last quarter, knowing that a lot of this stuff was happening. We're going to be pushing out this last quarter so that we don't get into the non-compliance by year end. Well, that pushed us right to 1 o'clock, Donna. As we kind of said, it was going to be a meaty topic. There's so much in that law. There's so much in 1203 that I know we only skimmed the surface of each of them. And I know there's a bunch of questions that also came through the Q&A that we'll go back and answer after the fact. Just couldn't get to everything. And we have some specific questions in there that we'll try to tie back. So again, Don, I want to thank you. Great intel into all these things that are happening and throughout the community. So really, thank you very much.
It's been my pleasure, Brian. Thank you.
And thanks for all of our guests and participants. So have a wonderful afternoon. We'll see you out next time on our webinars. Bye, everybody.